Well, a very good question. Actually, there's several aspects of that. First of all, let's start with the will. It is common to find that the will is defective. It doesn't do what the person wants. One of the first things is to have not reviewed your will for 30 years, and the person you named as executor is dead. That's the first thing, so we've now got to find somebody else to be appointed as administrator. The second thing is you've mentioned specific properties. So you left the house at 19 Brown Avenue, Claremont, which you sold 10 years ago, to a beneficiary. So they don't get it because you don't own it. If your will deals with specific assets that you don't own anymore, if it has named executors who aren't alive anymore, they create problems. But even worse are the wills that people have done themselves that have holes in them. We actually have a case at the moment with a will done by an elderly lady, quite wealthy, who hated spending money, especially on lawyers. So she did the will herself, and she left a very big hole in the will, which has led to an expensive legal battle now. We've had the court make a decision about what she really intended, despite the holes, and there's now an appeal against that decision. So we are making a lot more money than we would have out of doing the will in the first place. So please, don't give money you don't need to lawyers. Get them to prepare the will in the first place, and you'll save a lot of heartache. We actually had a businessman who made a fortune and decided that he could use all this time he had on his hands to do his own will, and it was a very complex will. And he spent months and months and months drafting it himself, and he'd add another chapter the next month. And then he died suddenly, very young, way before any of us would have expected him to die. And I was one of 6 or 7 lawyers who read the will and couldn't agree on what it meant, because parts of it contradicted. What he added 3 months later, he'd forgotten to reread what he put 3 months earlier, and there were contradictions. So that meant an application to the court to have the court interpret the will. That added about a year, during which time nobody could do anything. Cost about $100,000 all up, because there were a lot of people affected by it, and there was a lot of money involved. And then the judge wrote an 85-page decision explaining what the will should have meant. So please, just get the will prepared properly in the first place. And the other consequences of dying without a will can really upset families. Let's say that your 40-year-old daughter is killed tragically in a car accident. Happens reasonably regularly. People in their 30s and 40s are killed in car accidents. And she doesn't have a will. She doesn't have a husband, she doesn't have children, but she's got 2 parents who had the most bitter and unpleasant divorce, one of whom is very close to her and one of whom she cannot stand. They're going to equally share in her estate. The one she would have liked to get everything is going to get half, and the one she would have not wanted to get anything is going to get half. So it's not going to be what she would have wanted. That can be one of the potential consequences. Even if you have a husband or wife, if you don't have children, other members of your family, including people you don't like, can receive a share of your estate. You would think, oh look, it's just me and my husband, we don't have children. If I go, it'll automatically all go to him. Not true. Or even more complex situations. Most husbands and wives own their home jointly, which means that if one of them dies, it automatically goes to the survivor. It doesn't form part of the estate. It's not dealt with in the will. But if, for some reason, and I've had it happen, the real estate agent who sold you the home put the 2 of you in there as tenants in common, so each owning half, your half isn't automatically going to go to the other owner. And if you don't have a will, that 19-year-old son who's a drug addict and who is very estranged from you and your wife is going to have a share of your half when you die without a will, which is going to cause terrible problems for your widow who's grieving and finds she doesn't own the other half of the home. A share of it now belongs to the 19-year-old whom she doesn't even want to see. So the consequences can be fairly frightening. On the EPA and the EPG, another horror story, man injured in hospital in a very serious condition, unconscious, his children of his first marriage around the bed. His girlfriend, who claimed to be his de facto, was meanwhile at his house cleaning out all the valuables. When the police were called by the children, she said, "What are you talking about? I'm his de facto. I'm actually legally closer to him than his children." Nobody had an EPA, nobody had an EPG. It really is quite concerning. Most people have no idea of the sorts of problems they can face if people don't have a current valid will or an enduring power of attorney or an enduring power of guardianship. So please, whatever else you do, doesn't have to be me, just find a good lawyer who knows what they're doing and make them.